This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Supreme Court Clerk Jim Hibner, for the introduction. And thank you and your staff and the staff of the AOC for making this possible to Zoom these arguments. We want to thank the lawyers for their participation today as well. And we want to welcome everyone to this, the second case of the February docket in Nashville, Tennessee for the Tennessee Court of Criminal Appeals. Mr. Clerk, I'd like for you to call the case and then I'll explain to the lawyers how we will proceed.
State of Tennessee versus Michael Keith Clark.
Thank you very much. Gentlemen, I'd like to introduce the panel that is going to be the panel serving your case today. On the screen, it would be to my right, Judge Robert Holloway from Columbia, Tennessee, and to my left, Judge Robert Wiedemeyer from Nashville, Tennessee. I'm John Everett Williams from Huntington, Tennessee. Each side is given 20 minutes. It's just as if we were in person. We appreciate you helping us do this. It is our way of trying to reduce any spread of COVID, and it also helps us keep our cases going in a timely fashion. With that, the appellate could reserve time for rebuttal if they do choose to do so after you introduce yourself to the court, and appellate time starts now. Thank you.
Thank you, Your Honor. May it please the court, I'm Roger Manus of the Clarksville Bar. I'm joined here today with my colleague, Colleen Hyder, who allowed me to work on this case with her and help her try the case in the trial court and work on in this court, work on the brief and do oral argument today. I'd like to reserve 5 minutes, if I may, for rebuttal.
Yes, sir.
All right. Y'all have to proceed, Your Honor. All right. May it please the court, we've raised three what I believe to be fairly discrete issues in this matter. The first one involves what we contend was an inappropriate limitation on cross-examination of the state's main witness in this case, Agent Gagnon of the 19th Judicial District Drug Task Force. The second issue has to do with the corroboration of an accomplice testimony as that relates to the sufficiency of the evidence on one count of the indictment in respect, and that was original count 9, which was at trial count 3 involving the possession of a firearm. That's important in the overall perspective of this thing because it's an automatic 3-year add-on increase of the day for day of the sentence in respect to that gun possession. In the context of a felony. So there's a lot of interplay between those first two issues. And the third issue kind of stands on its own. It's an inappropriate reference in final summation, rebuttal summation to the fact that the defendant did not testify, an indirect reference to that. So what I would like to do first is I will tell the court that we told the trial court really 3 times that we intended to do this because there was a change at the last minute in the state amended the indictment and deleted several counts of the indictment, 6 counts, I believe, changed our strategy. So we, knowing that the state had received the tox report in mid-February and that agent and that really only revealed one substance that was for which Mr. Clark was charged, and that Agent Gagnon 3 weeks later had gone to the grand jury and saw an indictment under oath for 6 other substances that were not 5 or 6 other substances that were not reflected on that tox report. We thought that was fertile ground for cross-examination of Gagnon, in as much as Gagnon was going to testify to an oral confession, not much of testimony, I will say, and we'll discuss that in a minute. But Judge, I don't see my time on the screen here.
It's not. Well, I'm keeping up with it. You got 3 minutes. So you just been talking 3 minutes. You're doing great.
Perfect. Well, the last one I did one a week or two ago in the Court of Appeals, and it was on the screen. And I wasn't sure if I was missing something here or not. So anyway, thank you for that. But in the state's brief on page 12, I think there's a critical admission. Page 12 of the state's brief. Now, if I may read briefly from that, about midway down the page, the state asserts Clark may have been entitled to show that Agent Gagnon's grand jury testimony was inconsistent with his testimony at trial. Well, we think that's a pretty critical admission, because the way that would be accomplished, given what we knew and what we were confronted with on the day of trial, was a simple step-by-step cross-examination. You received the tox report on February 15th, mid-February. The tox report said this. It basically said methamphetamine. You went to the grand jury 3 weeks later, and you swore the grand jury under oath that this defendant was guilty of having possessed with intent to sell 5 or 6 other substances, which you don't have a tox report for. You did not have a tox report for. And so at the time you gave that testimony, you knew or should have known that it was false. Now that becomes important because of this admission testimony later that goes directly to the state's theory that Mary Ann Bensley, the accomplice, that her testimony was corroborated by a confession, essentially, of Mr. Clark. So Agent Gagnon's credibility in this case is of critical importance, both to the underlying charge and certainly to the gun charge later on, because there's a lack of corroboration there, we believe, in respect to that. And his testimony is what's relied on to corroborate Mary Ann Bensley's testimony. So the trial court made a determination on an offer of proof that we would not be allowed to cross-examine about the original indictment on it, and in a manner that I just expressed to the court on it. And the state says that, well, the trial, it's certainly within the discretion of the trial court, nobody disputes that to govern the examination of witnesses, direct and cross-examination. Nobody disputes that. But it's also not disputed that the right to cross-examination is part and parcel of the right to confront witnesses under the Sixth Amendment. So it's it's derived from a constitutional right, and it's of critical importance in this case. Now, our position is, and we think that the state has essentially confirmed that later on in their brief, that it was not for the trial court to determine whether Agent Gagnon's explanation for why he did what he did, in the timing and manner in which he did what he did, it was for the jury to determine that. Agent Gagnon was very crafty or cagey in his testimony in more than one way. In particular, this issue about this tox report, because during the offer of proof, I cross-examined him, and he says, well, I didn't know about it until the day of trial. I didn't have access to it. It's password protected, blah, blah, blah. But then further on down, when you probe a little deeper, it surfaces. All I had to do was ask for it. All I had to do was ask Agent Darnell for it. He would have printed it, and I would have had it. So the 19th Judicial Drug Task Force had it. They had the tox report in mid-February.
They didn't have to take it. He could rely upon what his expertise as an officer in dealing with drugs and what he saw and what he did. We're just looking at a probable cause determination, and that's pretty minor discrepancies there. Is if he thought it, and then when they finally came back and realized what they had, they dismissed it. What's the problem?
Well, that's certainly an explanation that the jury could have believed. But they also could have believed that he lied to the grand jury about it. And they also could have believed that the state botched the case. So there's really 3 alternatives here in terms of what the trier of fact could have believed, one of which is benign, as the court just enunciated, and the trial court enunciated, and it was the state's theory. But in terms of
do you have any testimony, or do you have any case law that supports bringing grand jury testimony relevant into a trial?
bringing
How
grand
do you-
jury
How do you
testimony.
get grand jury testimony in at a trial?
Well,
Never seen it happen.
It's prior sworn testimony. It's prior sworn testimony by the witness about the subject matter.
Well,
The
how
prior
do you know?
inconsistent
How do you know that if it's secret? If grand jury proceedings are secret, how do you know who testified to what in a grand jury?
I know that because he admitted he went and he testified under oath, and the product of the grand jury was a multi-count indictment for meth, amphetamine, marijuana, oxycodone, OxyContin. It's reasonable to conclude, and for the trial jury to conclude, that the grand jury didn't just dream that up. It had to have some evidentiary support, and Agent Gagnon was the only witness before the grand jury. So Gagnon went in, swore under oath. This was the product of his testimony. And his testimony, his prior testimony, what he testified to, if it's inconsistent with what's going on at trial or the evidence that they had, it's an inconsistent statement. Under it's fertile ground for cross-examination.
Yeah. Respectfully, you don't have a statement. You don't know what he said. So
Well,
how can I conclude that grand jury proceedings are secret?
Well,
And this is just a lot of conjecture, and this is a lot of speculation. I have no idea what he said. So how do we know that it was an inconsistent statement? It may have very well been consistent.
we know that.
What he testified to.
We know that because the product of the grand jury was an indictment for all these other substances, which are not reflected on the tox report. That's how we know that. The grand jury, it would be an exercise in, well, it would be unreasonable and illogical to conclude that the grand jury had not, had just dreamed all that stuff up. It had to come from somewhere. And he was the only witness before the grand jury. The only sworn witness before the grand jury listed on the indictment was Agent Gagnon.
But you don't know what he said.
Well, do I know precisely what he said? No.
You have to know precisely what he said to determine whether or not this was an inconsistent statement.
I can ask him what he said is the point.
I think grand jury proceedings are secret. You cannot.
Well, they are secret. I don't know that they're secret in this context. In terms of asking the witness.
That's what I'm asking. Do you have any case law that supports that you can ask about grand jury testimony during a trial?
I don't have any case law in regard to that. But what we're wanting to do in this case was ask about the, in the context of the tox report. I mean,
if the grand jury had dismissed it, if he had gone in front of the grand jury and asked for all these charges and the grand jury had come back with a no true bill, would any of that be relevant or admissible?
It wouldn't be, but we wouldn't be having this discussion either. Under that scenario, it wouldn't have been a trial.
Well, there was just a trial on one.
Well, I understand, but that's not what happened though at the grand jury. The grand jury indicted on 6 substances. 6 or 7.
Okay.
And it had to come from somewhere. So,
I've just never seen where a grand jury testimony becomes relevant and can be introduced in a trial of the underlying case. And I know you don't have an inconsistent statement because you don't have any idea what the inconsistency was. You don't have a statement. You just don't know. All you got is a product of a grand jury, and they could have been rogue. We don't know. And that's why grand jury proceedings are secret.
The state has acknowledged, has conceded that Clark may have been entitled to show that Agent Gagnon's grand jury testimony was inconsistent with his testimony at trial.
And I don't have to accept that, do I?
Well, you don't. That's correct. But
thank you.
But I am simply pointing that out to the court. So now, may it please the court, I'll move on to the other issue.
Let me just ask you one question. Did you seek an offer of proof or some type of testimony outside the presence of the jury?
We did.
Okay.
Your Honor. It's in the record at great length on it. We made an initial statement prior to the beginning of the trial. In the course of the trial, we did, and we made an outside the presence of the jury. We did an offer of proof, question and answer offer of proof with Agent Gagnon on the witness stand. Now, moving on to the second issue, the court will note that we limited the sufficiency of the evidence argument to the count 3 of the indictment and trial involving the possession of the firearm during the commission of the felony. We believe that the only testimony that connects this man, or the only evidence that connects this man with this firearm is the testimony of an accomplice. There's no question she's an accomplice under our law. She's co-indicted with him in the same indictment, same charges, identical on it. So she's an accomplice. She testifies. Her testimony is the only testimony that links up Michael Clark with his house, with his safe, with his gun, period. The admission, the alleged confession given to Agent Gagnon, which he sort of blithely referred to as in a nutshell, in a very general way, in no respect touches on the location, dealing drugs out of this house, there being a gun at this house, living at this house, leasing at this house, owning this house, nor is there any proof of that at all. The only thing connecting this man with this house in this trial is the fact that he was present there, along with 2 or 3 other people sleeping in a different room in a recliner than where the safe was and the drugs and the gun. We know Marianne Bensley had access to it because she admitted having gone into it and gotten some meth out herself. And we know that she was connected to the house because we introduced an utility bill in her name in it. But the state introduced no evidence connecting Mr. Clark to this house other than the testimony of Marianne Bensley. The admission, if you believe it, happened, which is in and of itself questionable. This man was placed in an interview room that was audio and video recorded. Sat there for an hour or 2 sleeping. There's absolutely, but there's no recording, no writing, no nothing. But the agent says, well, this in a nutshell is what he told me was low-level method. But he didn't talk about anything but that. A very generalized, alleged confession here on it. And of course, he doesn't, in that respect, he doesn't confess anything about the house or the safe or the gun. So our case law says that mere presence in the location is in and of itself insufficient to serve as a basis for constructive possession. So the state really is kind of relying on they are relying on the admission, the alleged confession, and the presence of Clark in the house to corroborate the testimony of Marianne Bensley. And in respect to this safe and this gun, neither does that. Neither is sufficient to establish that. The state could certainly argue that the confession stands as corroboration for the meth conviction, but
you're starting to get in your
that in and of itself is attenuated. Even that in and of itself is attenuated. Because the meth was taken from the safe, and there's just no connection there. But there's no connection whatsoever. There's no corroboration whatsoever in respect to this gun thing.
You're getting into your rebuttal time now. You may continue, or you have 5 minutes.
I will. If the court has any questions for me, I'd be happy to answer them. I'd like to. I appreciate you telling me. I don't have the benefit of seeing it on the screen, so
yes,
so very good. So.
Well, the civil courts deal in money, and we deal in lives. So we figure lives are not worth putting a clock on. Money might, but lives aren't. So we try to be very liberal with you here, Counselor. Thank you so much, and you've got your entire 5 minutes ahead available. Thank you. Let's hear from the state.
It please the court. Jim Gaylord on behalf of the state. Well, as Judge Williams has pointed out, the question of grand jury secrecy looms large in this case. But the fact of the matter is that there is no inconsistent statement here that would have been relevant, so the trial court properly excluded this cross-examination. What Agent Gagnon testified to at trial is that we found methamphetamine in the residence. From the proffer, they found some additional substances as well. But the fact that they found additional substances is not inconsistent with there being methamphetamine in the house. So this line of questioning was irrelevant and likely to be confusing or misleading to the jury. So here's what happened. They found the methamphetamine. They also found 6 other substances. Agent Gagnon consulted a standard reference work to identify those substances, and evidently he went before the grand jury, presented those results, and an indictment issued. Unbeknownst to Agent Gagnon at this time, TBI had issued a lab report that showed positive results for methamphetamine and for 2 other substances that aren't at issue here today. When the prosecution learned that all of the substances had not been tested, they dismissed the other 6 counts of the indictment, proceeded only on the methamphetamine charge. Well, it was entirely appropriate for the trial court not to allow the defense to delve into this matter. As to the lab report, Agent Gagnon isn't a competent witness. He didn't generate the report, and in fact, the proffer indicates that he did not know about the report until the day of trial. So he can't be asked about something as to which he has no personal knowledge. Now, he does know something about other substances that were found in the house, but the state did not proceed on those at trial, so it was simply irrelevant. And what the project seems to be here today or at trial was to suggest that he had engaged in some kind of misconduct before the grand jury by testifying to what he did, even though there was a report that might suggest that either the TBI didn't test everything that they got or that a different agent didn't send everything that was recovered to TBI. But neither of those possibilities reflect on Agent Gagnon's credibility. So the trial court properly kept it out, and had it come in, it would have been potentially confusing and misleading. And because it does not bear on his credibility, it was irrelevant. So the trial court properly exercised its discretion in curtailing this line of inquiry. If there are no questions on that matter, I'll address the sufficiency of the evidence. The accomplice's testimony is roundly corroborated. Basically, the accomplice testified here that the defendant is dealing methamphetamine out of this residence. That is corroborated by defendant's confession that he was dealing in methamphetamine. His being found in the house, methamphetamine being found close at hand, and being found in an amount that was not for personal use. It was more than 2 grams, and methamphetamine is sold in tenths of a gram. And loaded handguns were found right next to the methamphetamine. That's sufficient to corroborate the accomplice's account. And the suggestion seems to be that everything that the accomplice said had to be corroborated, but that's not the rule. The rule is there just has to be corroboration of wrongdoing and the defendant being involved in that. And his admission, his presence in the house, and the discovery of the substances in the gun are sufficient to establish those facts. So there's not a sufficiency of the evidence problem here. If the court would like me to address the prosecutorial comment issue, I'm happy to. Now,
rely on your briefs, it'll be fine.
That would be fine. If there are no further questions, then we would ask that the judgment be affirmed.
I have just one question. Was there any corroboration of the accomplice's testimony as to the ownership of the firearm, other than the fact that it was found next to the methamphetamine in the house where they both were in the safe?
I don't believe so, but I think the fact that it's found right next to the drugs, which the jury can assume that he's dealing in because he's found there and he's admitted to dealing in methamphetamine, is sufficient. Thank you for your time.
Thank you. You have your full 5 minutes for rebuttal, please.
All right, thank you, Your Honor. Am I off mute now?
You're yes, sir. You're fine. We hear you.
Perfect. Okay, good. Well, I'm very low tech, so I've got the assistance of my son here working with me today, who's a lawyer in this firm, and I have to rely on him in that regard. But I think Judge Holloway's question goes to the heart of this thing. There is no corroboration. The state's argument on this thing was interesting to me in the sense that it painted with a very broad brush on this corroboration thing. It just has to be corroboration of wrongdoing. I don't think I've read a case that says that. In fact, I cited cases in our reply brief that say to the contrary in that regard. Just general corroboration that proves that he was there and could have been involved in non-specific wrongdoing is insufficient. We've cited the case law on that from this court, and that's a serious flaw in this case. Now, we cited a case out of Memphis that I was fascinated by. I was working on it. I do a lot of appellate work. Admittedly, most of it's civil. This is the first felony case I have tried, and since before Judge Wiedemeyer, I went on the circuit court up here, and that's been a while. But I tried a lot back in the day when we were having to take appointed cases back in the 1980s. So I'm not unfamiliar with this territory, but I came upon this opinion out of Memphis, this Jones case, and I was fascinated by it. Now, about the only thing that I can see in that case that's really distinguishable from this case is that they didn't have accomplice testimony in that case. Both defendants stood mute at trial and didn't testify. But the crux of the case is that mere presence in that hotel room with 2 beds disturbed, both of them mussed up, drugs everywhere, guns everywhere, every other kind of thing going on, heroin, in fact, in this case, was insufficient. His mere presence in the room with the other guy, for whom there was already a warrant, apparently, that had been issued on it. But the state sort of walked around that in its brief in this matter, and it just seems to me that a finding that he was in a room in the house asleep along with 2 or 3 other people is insufficient to corroborate the testimony of Miss Bensley in this thing. Miss Bensley had meth in her purse and had admitted to having gone in the safe herself and the night before and gotten that meth out and put it in her purse. So we know she had some connection with this residence because of the utility bill. So the confession, if you believe that occurred, which the trier of fact would have to be the judge of that, obviously, doesn't address this issue of the gun or the safe or anything like that. And Agent Gagnon had to admit he had no testimony whatsoever that this particular defendant had ever been seen with this gun, with a gun, brandished a gun, used a gun in a commission of a felony at all. This gun's just in the safe in a house in which he was found asleep in an adjacent room, another room in the house. So that's the connection here, and there is no more connection than that to corroborate Miss Bensley's testimony. Now, I'll be happy. I don't know where I am on it at this point in time in terms of my rebuttal argument, but I'd be happy to answer any questions that any of the members of the panel have about any of the 3 issues. I didn't have time. I ran out of time on the other to address the others. I'm not going to try to bring that up in rebuttal. I don't think that would be appropriate on the issue of the. I think we addressed it in our brief, and we did make an objection, and I think it was a timely objection. So it is what it is in that regard. Does the court have any questions for me at this point on any of the 3 issues that we have raised?
I don't hear you, Mr. Manus, and thank you so much. It's just a pleasure to have good lawyers before you, And I know you've got you say you're low tech. You can't imagine the staff that we have behind us trying to get us to look this good. So you've done very well, and wish you would come back more often. I know you're by reputation and your advocacy in the civil arena is greatly revered. And you did a fine job here today, and so did Mr. Gaylord. And it just really helps us. The briefs are good. We can take, if you don't feel shortchanged by not getting to that. We'll look at the briefs, adequately both sides covered, and it's just a pleasure to work with good lawyers today. And thank you for your arguments on both sides. The issues are very well joined. And with that, we will stand adjourned to the next case at 11 o'clock.
This honorable court is now